Well, good morning or afternoon, everyone, depending on where you're joining us from today. My name is Shane Starkey, and I'm joined by my colleague Nathan Holmes, and we'd like to welcome you to today's webinar. We will be covering updates on executive compensation matters today, and this webinar is the first in a series of 4 slated every Thursday at noon for the next 4 weeks. Each webinar will explore a different benefit-related topic. Please join us every week or just for the topics of interest to you. You can register for additional seminars through the invitation that you received. During the webinar, please feel free to use the question panel at the upper right-hand corner of your screen to submit questions. We will answer questions at the end of the webinar as time permits. Any questions we do not answer during our time together today will be responded to via email after the webinar. So we are going to start with the topic of Section 162M of the Tax Code. That is on your first slide there, and I'm trying to get my slideshow to work. So we'll get the slideshow to work, but I will start with a brief overview of Section 162M. Prior to the Tax Cuts and Jobs Act, Section 162M provided that a public company could not take a federal income tax deduction for compensation that it paid to any covered employee to the extent that that compensation exceeded $1 million. And that rule is still in place, but there are a couple changes. Under prior law, a covered employee was really a limited group of individuals. It was anyone who, on the last day of the year, was the CEO or one of the next highest compensated executive officers as reported in the proxy statement. The CFO was not impacted by Section 162M, so it was just the CEO and 3 other top paid executive officers for a total of 4. And importantly, there was a major exception to this $1 million deduction cap. And that exception was that qualified performance-based compensation paid under a stockholder approved plan was disregarded when determining whether an employee was paid more than $1 million. So typically stock options and performance shares and annual bonuses could be structured in a manner that would not count towards that $1 million cap.
Now, Shane, this is Nathan Holmes. Shane, before you go on, we might mention as well that there have been and still are some special rules under Section 162M for particular circumstances that we're not really going to address today. There are different limits that apply, for example, for health insurance, certain health insurance providers under Section 162M, but we're really talking about the general principles that apply to most other publicly traded companies.
That's right. And when we say publicly traded, we're talking about you have equity that's publicly traded or debt that's publicly traded or certain foreign private issuers. But under the Tax Cuts and Jobs Act, Section 162M was modified in several important ways, effective for tax years beginning after December 31st, 2017. And first is that it repealed the performance-based compensation exception. And so that's a big deal because, number one, a lot of companies have a lot of performance-based comp sitting out there already, and we'll get into some transition rules, but that was the big exception, and that was, the huge loophole that people could use to get around this rule, and that now is repealed. So any compensation generally is going to count towards the $1 million cap. And second, the Tax Reform Act expanded the definition of covered employee to pick up anyone who's serving as a CEO or CFO at any time during the fiscal year. So not only does it pick up CFOs, but it's saying anyone who's CEO or CFO at any time during the year is going to be a covered employee. And then it picks up the next 3 highest paid executive officers. And then, amazingly, it says that any person who is a covered employee for any tax year beginning after 2016 will continue to be a covered employee forever. And so it's a once a covered employee, always a covered employee type of rule.
And that rule applies even, there's a specific provision in the Act that says, that makes it clear that rule applies even to benefits that are paid after the death of a covered employee.
That's right. Now, one thing that we're really focused on, and we'll dive into this in a little bit, is that the Act has a grandfather rule, and it says that changes made to Section 162M are not going to apply to any comp that's paid under a written binding contract that was in effect on November 2nd, 2017, provided that contract's not materially modified. And with that, we just recently got some notice from the IRS, and I'll flip ahead here. I can. We have IRS Notice 2018-68, and that's where the IRS gave us initial, their preliminary guidance on how these new rules work relating to the identification of covered employees and the operation of the grandfather rule. And Nathan's going to walk us through that notice.
Mm-hmm. And I'll start with the covered employee definition. As Shane mentioned, the notice is the initial guidance from the IRS. We should expect more will be forthcoming, but it addresses two of the key topics: who are the covered employees, and how does the grandfather rule work. And the real sort of takeaway on the way that the notice interprets the definition of covered employee, I think key points to notice are that there's no need for someone to have served as an executive officer at the end of a taxable year in order to be treated as a covered employee. And there's various ways that former employees still end up being treated as covered employees. And also that there's no need for the individual's compensation to actually have been subject to disclosure being required under SEC rules. And so while there are some provisions like adding back in the CFO that tends to harmonize a little bit the way the IRS rules work and the way the SEC's rules work, the way the notice interprets the statute, I think more broadly reflects a growing divergence between who your covered employees are going to be for Section 162M purposes and who your named executive officers or NEOs are going to be for purposes of proxy statement reporting. And so let's start there just to get a baseline, because these are the rules that have been around since 2006, I believe, under the SEC's rules. Who's a named executive officer? Well, first of all, a named executive officer, or NEO, is a subset of the company's executive officers, which are going to be folks designated by the board of directors, who are your president, a vice president in charge of a principal business unit or function, or other people who have a policy-making function with respect to the company. But there's sort of two general categories, or two rules that apply for identifying your NEOs. The general rule that applies to most public companies is your NEOs are any person who served as CEO at any time during the year, any persons who served as CFO at any time during the taxable year, or during the fiscal year, last completed fiscal year, and the next three most highly compensated executive officers. Again, so it's got to be an executive officer, not just an employee, who's serving in an executive officer role at the end of the year, other than the CEO and CFO, and up to two additional individuals who are no longer executive officers, but would have been among the three highest paid, other than CEOs and CFOs, if they had continued serving until the end of the year. That's the general rule. There's also a special rule under the SEC's scaled disclosure rules for smaller reporting companies and emerging growth companies. And here the SEC has sort of relaxed rules to make it easier for these smaller companies to comply with the disclosure requirements. So SRCs and EGCs, smaller reporting companies and emerging growth companies, are not required to comply with the general rule and certain other provisions of the SEC disclosure rules. And the NEOs for an SRC or EGC are all persons serving as the CEO at any time during the year. The CFO is not a named executive officer of a small reporting company or emerging growth company merely by virtue of title, like the CEO is and like the CFO is for, we'll see for the covered employee definition now. So this anyone who serves as CEO at any time during the year, and then the two most highly paid instead of three executive officers who are serving at the end of the year, other than the CEO, and often that will pick up the CFO by virtue of compensation. And then again, up to two additional individuals who are no longer executive officers at the end of the year, but who would have been among the two highest paid other than the CEO if they had been serving at year end. So that's the securities law definition. For your proxy statement reporting purposes, these are the folks, depending on which rule applies to you, whose compensation is going to be reported in the summary compensation table, discussed in the compensation discussion and analysis, the CD&A section of your proxy statement, et cetera. Our next slide, this gives us a summary of what the rule is now after the for covered employees for tax purposes, for purposes of Section 162M. This is the rule that's going to apply for fiscal years beginning after December 31, 2017, for identifying who's subject to Section 162M. And here, one test applies to all affected companies. It doesn't matter if you're a smaller reporting company or emerging growth company. The test is, as summarized here, as interpreted by the notice. It is anyone who's serving as CEO at any time during the year, anyone who serves as CFO at any time during the year. So those first two are consistent with the NEO definition for under the general rule for securities law purposes. And then employees who are among the three most highly compensated executive officers other than CEOs and CFOs for the year, but as the notice interprets it, regardless of whether they're serving in that capacity at the end of the year, and regardless of whether their compensation is actually subject to disclosure under the SEC's rules. And then, as Shane mentioned before, we also have the once an employee, always a covered employee rule. So anyone who was a covered employee in a prior year is going to be, starting with 2017 years for calendar year companies, is going to continue to be a covered employee in subsequent years. So to help illustrate how these rules work under Section 162M for identifying covered employees, we have an example here that is drawn from an example in the IRS notice. If we click ahead to that next slide, here's our example. We have a publicly held company with a December 31 calendar year. And for 2018, they have one CEO, that's employee A, two CFOs for a portion of the year, employees B and C. Then we have employees D, E, and F, and they were the first, second, and third most highly compensated executive officers other than CEOs or CFOs for the year. But in this example, all three of those employees retired and were no longer with the company before the end of the year. Then we have employees G, H, and I, who were the fourth, fifth, and sixth most highly compensated executive officers other than CEO or CFO individuals. And those were the active individuals who are still serving as executive officers at year end. So the questions become, all right, in this example, who are your named executive officers, or NEOs for securities reporting purposes, and who are the corporation's covered employees for purposes of Section 162M? Shane, do you want to take a shot at the first question? Right. Who are the NEOs for securities law purposes? Right.
So assuming you're not a smaller reporting company, it's A, who's the CEO, B and C because they were served as CFO at some point during the year. Then you have G, H, and I. They're the three most highly compensated executive officers who are there on the last day of the year. And then you got to throw in D and E because even though they're not there at the last day of the year, had they been there, they would have been among the top highest paid executives. And so, I mean, then it flips back, who are the covered employees? Nathan, you can handle that one.
All right, so here we go. So the corporation Z's covered employees for 2018, we start out the same, right? The A, who's the CEO, B and C, who were the CFOs for a portion of the year. But then things begin to diverge a bit. We have D, E, and F, who were the three most highly compensated executive officers serving at some time during the year, none of whom were serving on the last day of the year. Those are your covered employees with respect to 2018 compensation, and you'd also have anyone who was a covered employee for 2017. That person would also be picked up as well. It doesn't matter in this case whether you're a smaller reporting company or emerging growth company. Those are going to be your covered employees in this example. And it's interesting because employee F is getting treated as a covered employee subject to Section 162M, even though that employee was not a named executive officer in 2018, and she might never have been, depending on when she became an executive officer, an NEO for securities law purposes. Also, employees G, H, and I, who were clearly named executive officers, they were the executive officers who were serving at the end of the year. They're not covered employees unless they were picked up in a prior year, and of course, they were serving at the end of the year. If they continue to serve into the next year and have a high enough comp, they'll become covered employees. But you get this divergence between what the securities laws say, who are the people whose compensation needs to be disclosed, and who's going to be subject to Section 162M for tax purposes. So and it can get even more complicated when you've got a small reporting company or emerging growth company or more divergent. So I think it's not going to be as simple in terms of figuring out who are your covered employees. It's not even as simple as looking at the proxy statement, each year and in prior years and seeing who's reported. There's really a separate analysis now under the tax rules.
That's right. And so aside from that, what we've been focusing on is of immediate concern, which is application of the grandfather rule. And the changes that we talked about, as I mentioned, do not apply to a written binding contract that was in effect on November 2nd, and which hasn't been materially modified. And really, when you're looking at a written binding contract, it's a state law analysis. So the company has to be obligated under state law to pay the compensation. And contracts that are terminable by the company without the employee's consent after November 2nd or subject to renewal are going to be kicked out of the grandfather rules at the time of the renewal or at the time that they could be terminated. The notice goes through in some detail about what's a material modification. Obviously, if you're going to amend an arrangement to increase the compensation payable under the arrangement, that's going to be a material modification. Accelerations of payments could be a material modification unless the accelerated payment is discounted. Deferrals are typically okay as long as the deferrals are going to earn subject to earnings based on actual investments or reasonable rates. But the piece that everyone's focused on is the impact of negative discretion under outstanding arrangements and the impact that has on the material binding contract exception. And so this is the IRS example that they gave us, and unfortunately they gave us an example that doesn't really fit well with the real world. They describe an arrangement that you don't typically see. But as you know, with performance-based compensation arrangements, most companies would set up the goals and there would be objective goals and such, but then the company would always retain discretion if it wanted to reduce payout, and that was permissible under the old rules. And it was also seen as a good governance practice to have the compensation committee retain some discretion to reduce payouts based on, any number of factors. And so the question is, does negative discretion kick you out of the grandfather rule? And so the IRS gave us this example. They say an executive is entitled to a cash bonus of $1.5 million if a specified performance goal is satisfied. But then the company retains the discretion to reduce the payout from 1.5 all the way down to 400,000. And the IRS has assumed that on November 2nd, under applicable law, the bonus plan constitutes a written binding contract to pay $400,000. So the IRS comes around it in kind of a different way, but it says, clearly, you can, the $400,000 is pursuant to a written binding contract, but nothing in excess of $400,000 is going to qualify for the grandfather rule because, according to the IRS, you're not obligated to pay it. So even though you could get a maximum of 1.5, since you could reduce the payout all the way down to 400, we're only going to let you grandfather the $400,000. And the frustrating thing about this example is that most bonus plans aren't set up that way. When the committee retains discretion, it doesn't say how far down it can take the bonus. I mean, basically, it's implied that they could take the bonus down to zero if they wanted to. And so we are working through state law issues, kind of going state by state to determine what impact just the mere presence of negative discretion has under state law on the ability to pay bonuses. And but I will say, initially it's not looking too good, but we're still looking to see if we can find some ways around this issue.
Yeah, I guess I would say it was not a completely shocking result based on some of the things that IRS representatives had been saying and in seminars, et cetera. But as Shane said, it is kind of a frustrating result. The example is not a common one and suggests a very difficult standard. I mean, they went sort of beyond just saying, well, you need to have a contract that's enforceable, to saying what they seem to be looking for based on this example is an obligation to pay either a fixed or a determinable amount that's in effect as of November 2, 2017. So you sort of have to be able to figure out or know what's the amount that a court would enforce. And again, it's a state law question rather than having a sort of consistent federal rule, really figuring out how this works puts you into sort of a deep dive into state law and the facts and circumstances of each particular compensation arrangement. And I mean, it's also frustrating, I think, for some of us, if I may go on, that negative discretion was so common and explicitly blessed in these arrangements. But this is where the IRS came out, but it produces some peculiar results. For example, if you look at things like, compare performance share awards where you have specified performance goals to be achieved, but negative discretion is retained, to a traditional plain vanilla stock option. And you have a couple of awards, the stock option and a performance share, both granted before the effective date of the rules. Well, it's very easy for the stock option to, in the normal case, to qualify as grandfathered and exempt from Section 162M because you typically didn't have negative discretion in the stock option, and it's performance-based just by virtue of being share price appreciation. On the other hand, it looks like it may be much tougher for a performance-based award where there's particular corporate objectives specified in the award to qualify as grandfathered for 162M purposes when, that's the way the market has been moving. And I think in common experience that many companies have been shifting away from stock options and towards performance share type awards for long-term equity incentives because that's what shareholders would prefer to see. But I think we may find that that shift may have less favorable tax consequences as a result of the way the IRS is interpreting the notice. We have another example, again, drawn from the IRS notice about how the grandfather rule applies. And in this example, we have employee V, who was the CFO of a publicly held company, and we're not dealing with a small reporting or emerging growth company. So in this situation, there's an agreement entered into before November 2, 2017, an employment agreement with the CFO that provides for an annual salary of $2 million for 3 years, for 2018, 2019, and 2020. The agreement will automatically renew for 1-year terms unless the corporation exercises its discretionary option to terminate the agreement within 30 days before the end of the term. So here we have a scenario where the CFO, we're talking about the CFO, so this is someone who, again, under the old law rules, would not be subject to Section 162M deduction limitation at all. And he has an employment agreement. The IRS says, look, this employment agreement that was in effect on November 2, 2017, even though the salary didn't really kick in until the next year, was a written binding contract to pay $2 million for each of the next 3 years. And absent some earlier modification by the company or the employee, some change to the agreement, those salary payments to the CFO under that employment agreement will be grandfathered and exempt from the $1 million limit under Section 162M until the end of 2020, when the agreement was renewable. And at that point, it'll be treated as renewed, whether it's renewed at that point or not. It's a new agreement, and the CFO's salary will be subject to 162M going forward after that. Not addressed in that notice, but a couple of other things that Shane mentioned before. When you talk about salary and adjustments to salary, an increase in the CFO's salary that doesn't exceed a reasonable cost of living allowance, that would not be treated as a material modification, but a increase above that would. So if the CEO's salary goes up significantly during this 3-year period, that would cut off grandfathering entirely. And if there's a cost of living adjustment, well, that wouldn't, or an increase in salary that doesn't exceed the cost of living adjustment, that wouldn't degrandfather the whole arrangement, but that increased amount under the IRS rule would not be exempt from Section 162M.
And we're going to move forward from 162M, but I'll just say that we're in the process of meeting with a lot of clients to identify which arrangements are grandfathered. And this is really kind of a fast track thing because public companies have a lot of deferred tax assets on their financials, and those deferred tax assets may need to be adjusted based on how we interpret these grandfathered rules. And you got to get those adjustments into the next Q or K. So these meetings are coming up fast and furious, and we're digging through a lot of documents. The other thing we're doing, of course, is gearing up for proxy season, and we're not going to take a deep dive into proxy season, but there was a recent development here that we are highlighting for clients, and that is, you may have seen, the Dow Chemical Company recently agreed to settle charges with the SEC for inadequate disclosure of perks. And they ended up having to pay a penalty of $1.75 million for failure to disclose perks, which, should get everyone's attention there. And they're also required to hire an independent consultant to recommend changes to how the company, does its perk disclosures. So, interestingly, the SEC found that over a 4-year period of time, Dow failed to disclose about $3 million of perks. So there was a lot there. And they included the CEO's travel on the corporate jet to outside board meetings, which I think everyone pretty much knows that's a perk. Plane trips to sporting events and personal activities. Sporting events, you would think if it were for business reasons and you're entertaining clients, maybe that's okay, but I guess the CEO wasn't doing that. Club memberships, again, club memberships for personal purposes are going to be a perk. If they're exclusively business related, maybe not a perk. The one that caught my eye was limited use of personal assistant office time. The reason that catches my eye is because, it says limited use, and I'm sure every company can come up with an example, maybe the CEO using his administrative assistant to, book flights for a personal vacation or something. I mean, how limited or how detailed is the SEC expecting companies to be with those types of situations? And then apparently the company is also paying this guy's fees to sit on boards of charitable organizations, which again is a perk. And apparently Dow was trying to defend itself, saying, well, these were all business related. The SEC characterized Dow's position as kind of a business purpose test that they were applying about whether something's a perk or not. But as you know, that's not the rule, and you have to look to see if the item is integrally and directly related to the executive's job duties, and these plainly were not. This came about, apparently, it's been reported that this came about through a whistleblower complaint where someone went to the SEC and told them what was going on. But it does really highlight the fact that, we're so used to these disclosure rules now, it becomes kind of routine, but there are real consequences to making sure you get these things right. And many of our clients, we meet with them to have a proxy statement kickoff meeting to review everyone's role in the process and to confirm the procedures for gathering and certifying the compensation information. And I recommend that everyone do that in some form or fashion and just kind of level set, because, your directors and top officers are going to see these types of orders and they're going to ask about them, and you're going to want to be able to really give them confidence that your processes and procedures are best in class and that you're accurately reporting the compensation.
In the next slide, we talk about a few other trends and developments we've seen recently in the executive compensation area, and that I think, expect to continue to see develop in 2018. And the first relates to disclosures for non-employee director compensation. There really has been some increasing scrutiny in recent years of director compensation, and I'll talk in a little bit about some developments in director compensation litigation, and also the institutional investor advisory services like ISS have been looking at director comp and other issues related to directors, overboarding, succession, et cetera. And as a result, we've been seeing companies really take another look at their director compensation disclosure and think about beefing that up to say a little bit more about director comp. I mean, there's no obligation to have a CD&A for director pay, but I think it's a good idea to look at what you're saying about the director comp and think about really telling the story of what's our program, how does it work, and very importantly, how do we determine what the right levels are for director compensation. Another trend we've been seeing recently, and I think it's likely to continue, is an increase in disclosures about stockholder engagement on a variety of issues, but particularly with respect to executive compensation. And it's really important, or particularly important, I think, for a company that may have had a fairly significant adverse or vote against total on a say on pay proposal, but even beyond, for those companies to go out and disclose to shareholders, hey, we've heard you, we went out and talked to shareholders, here's what we heard, and here's what we changed as a result of what we heard. But even beyond that situation, I think companies that are doing well on their annual say on pay votes are thinking about talking to shareholders on a more regular basis and trying to understand their views better and incorporating that into their compensation program design where it makes sense. As always, we'll have say on pay proposals again, and there, maybe some equity plan approvals. As usual, we'll be waiting for updated guidance from the institutional advisory services like ISS and Glass Lewis, and other institutional investors often have their own policy. So it depends on who your shareholder base is to think about what's important in your compensation program. A couple of points, obviously, there's already, we no longer need to go back to shareholders to approve equity plans at least every 5 years for Section 162M purposes. So that's one thing. So now you really only need to go back when you need more shares or you've materially modified the plan in the way that would require a reapproval under the stock exchange rules. But other than that, I think we're waiting to see what the institutional investors will say about changes to their program for this year. And it'll be interesting to see on the 162M point whether there's any guidance from ISS on what they like to see in equity plans. I think there've been some informal indications that some of the provisions that you used to have to include in your equity plan in order to have qualified performance-based comp awards, you wouldn't necessarily need those anymore. For example, there was a laundry list of performance goals that could be selected from for awards that were intended to be exempt from Section 162M. There were individual employee limits on compensation paid within a particular time period to your executives for awards that were intended to be performance-based. You don't really need that for tax purposes anymore, but institutional investors, ISS, may want to see companies continue to keep those types of provisions in plan documents. I mean, particularly the individual award limits is what they've suggested they'd like to see. And there may be other good reasons to keep the laundry list in the plan as well. On Section 162M disclosures, because calendar year companies have already addressed this, but if you haven't done it yet, if you're on fiscal year, you really going to want to take a look at what you say about Section 162M in your proxy statement. Don't want to overpromise anything there in terms of what may or may not be deductible or what may qualify for an exemption, and the rules just changed. So that's definitely something where you need to have an updated look at your disclosures that relate to Section 162M. In terms of, will those 162M changes, will they have an impact on compensation plan design? Shane, I don't know, what are your thoughts on that?
I mean, my guess is that ISS will come out and say that it still wants to see individual limits on awards. So we've had those in plans, solely to comply with 162M. We don't need them there anymore, but I would guess ISS is going to want to see limits, sub-limits under the plan there. We typically advise clients to keep in the laundry list of performance goals in their plans, just because we think as a conservative reading of the Form 8K rules, you need to have that list in there to avoid having to file an 8K every time you issue an award under those plans. Mm-hmm. And I guess, 162M used to require that you had to set your goals for your bonus plan and your performance shares within the first 90 days of the performance period. You don't have to do that anymore, but again, it's seen as a best practice, I think, at this point, to get things in place early on in the year. So, I mean, I would imagine we're not going to see a lot of changes, but, just driven by what others perceive as best practices under those 162M rules. Mm-hmm.
And in terms of plan design, I mean, I think institutional investors, shareholders generally are still going to want to see performance-based compensation in the meaning compensation that's based on the achievement of corporate objectives be a significant part of compensation, so we don't see companies making a wholesale shift to another sort of compensation just because it's not necessarily as tax favored as it was under prior law. This year will also be year 2 for the CEO pay ratio disclosure. Calendar year companies have already disclosed their CEO pay ratio for the first time earlier this year in their proxy statements. And again, I'm sure we all know what that is, but basically companies had to go through and look at their employee base and figure out a methodology for identifying who the median employee was from their employee population, other than the CEO, the person who's in the middle, and then disclose the compensation of that person, the compensation of the CEO, which is already otherwise disclosed in the summary comp table, and the ratio of the two, and then describe the methodology and any assumptions, adjustments that were used, and the rules really give a lot of flexibility to individual companies to determine their own, what they think is the most appropriate methodology for identifying the median employee, and even making some adjustments to how the ratio is calculated. So that's going to, I mean, my sense, Shane, I don't know if you agree, was that, it was a lot of work to get this together, particularly for multinational companies, but, depending on what your payroll systems look like, there was a fair amount of work in pulling this together for last year for the first time. But my sense was, you didn't get a very big negative reaction. People were anxious about how this might be perceived both by outside parties and, by employees at competitors, employees within the company. I think in many cases that became a more, a bigger focus is the HR impact, potential HR impact of these rules. It seems like, by and large, the first season of CEO pay ratio disclosure passed fairly quietly. Do you have that sense too, Shane?
Yeah, I do. And, everyone kind of knows what the CEO makes. There are always news articles about that. There always have been. Everyone knows the CEO makes a lot more than the average worker. But, the new number we got, really, aside from the ratio, was what the median employee makes at each company. And I know there was concern in the corporate community about disclosing that number and the impact it could have on morale and recruiting and things of that nature. But I just really think, I think it was appropriate to raise that as an issue and be concerned about it, but we just haven't seen it be an impact at all, really. It just kind of went as a non-issue. Mm-hmm. One thing that'll be interesting is to see how ISS will use the pay ratio disclosures, and it could be that they'll find a way to factor that into their analysis, which will be interesting to see. But that's for another day, I guess. Yeah,
once those data points are out there, they're going to be trying to find a way to use it. I think they've already indicated. Although, as you mentioned, there's a lot of flexibility in there, and so it's going to be hard to compare. It's kind of, you can end up with apples and oranges even in the same industry, and I think a lot of companies in their disclosures tried to point that fact out. That the SEC's rules gave us a lot of flexibility in how we determine this. Maybe it's not such a good idea to try to draw comparisons with other companies, but we wait to see what ISS and others may do in terms of how they might use these rules. But as we look forward to what you're going to do with the CEO pay ratio for next year, a couple things to keep in mind. One is, unless something has been materially changed in terms of compensation or employee population, you can continue to use the same median employee who you identified last year as your median employee for next year, and just recalculate their total compensation under the summary comp table rules and rerun the ratio. So just need to confirm whether there's been a material change or not. And you also need to either use a consistent methodology to what you did last year, or if there are changes in your methodology for how you determine who the median employee is and calculate the ratio, you're going to need to describe those changes. So, I think we've worked with a lot of companies to say, look, let's document what the process was this year so that it rolls forward smoothly, but we'll see how that goes in year two. And then I guess I would just, last piece of commentary on this before we move on to another topic. From what I saw, most companies took a very minimalist approach to CEO pay ratio disclosures. There were some cases where it made sense and you did see things like alternative ratios or explanations for something that might be a bit unusual, but generally the disclosures were pretty short and to the point, and so I would expect to see that continue, since that seems to be the way the market went. Any other thoughts on that, Shane, before we move on?
No, I agree.
Our next topic, I mentioned this briefly on a slide ago, there have been a number of shareholder lawsuits in recent years challenging non-employee director compensation as to whether compensation is excessive. Now, director decisions in general with respect to business activities of the company are going to be protected by the business judgment rule. But when directors engage in transactions where they are self-interested in some way, and this is, of course, a classic example where they're setting their own compensation, in that case, the entire fairness standard applies, and at least in Delaware law and most other states too, where it shifts the burden of proof to the directors to prove that the transaction is entirely fair to the company. That's a much tougher standard to meet. So from a plaintiff's lawyer's perspective, that's what you're trying to get to, right, to that entire fairness standard. There were some recent court cases, and a prime example from, I think this was about a 2012 case, was Seinfeld versus Slager, that basically where Delaware courts had approved a rule that if stockholders have approved a plan that includes a meaningful limit on non-employee director compensation, that basically that's a ratification defense. Stockholders have approved it, and that's going to keep you in the business judgment rule area and get you make it easier to survive a motion, or to succeed on a motion to dismiss. So if you shareholders had approved a meaningful limit on director grants, it seemed like that was the way to go. And in fact, in recent years, many companies, I know we've had advised our clients to do this, and many of them did, put limits in their stockholder approved equity plans on non-employee director compensation. You know, and there were a variety of ways to do this. In the initial sort of wave of limits on director compensation, often I think you would see the limit just apply to equity awards under the plan. The directors, you know, would not receive equity awards over a certain level. But as people looked at it and thought about it more, in many cases there was a transition in recent years to also including some sort of limit on cash compensation, director fees paid to the directors during the year, just to try to protect that as well, and just take the threat of potentially frivolous shareholder lawsuits off the table by having the shareholders approve a limit. Now, there's a variety of ways to draft those limits, but, you know, for example, one, and I think it's one common approach, was to state in the plan that the aggregate of the cash compensation payable to any director in a particular year, plus the grant date fair value of the equity awards granted in that year, would not exceed some specified amount, you know, a dollar amount limit. That's not the only way you could draft it, but that's one common approach that we saw and often used with our clients. And that seemed to work pretty well. You know, you come up with a reasonable number, you know, some multiple of what director compensation looks like, so that you're building in some wiggle room for, you know, new director situations, special awards for chairman, retention, et cetera. But you put some sort of limit in the plan, have shareholders approve it, and sort of try to take this issue off the table. That seemed to be working quite well until the end of last year, in December of 2017. On our next slide, the Delaware Supreme Court decided the Investors Bank Corp case and ruled that in this case, where stockholders were challenging awards to directors under a shareholder approved equity plan, the Delaware Supreme Court says, nope, entire fairness standard applies here, because the directors have discretion to set their award. They have to prove that this was fair. The only limit in this case on the number of shares that was included in the plan, the number of shares that would be granted to directors, what the plan said was no more than 30% of the overall share reserve under the plan could be granted to the directors. You know, so it was a limit really over the life of the plan, awards to all directors. I mean, as I read the plan that was issued in that case, they could have granted, you know, 30% of the overall share reserve to one director on the day after the plan was approved by shareholders, and that would have been within the limits. Again, that was some sort of limit on director compensation. Was it a meaningful one? You know, it's certainly not the type of limit I would have included. There were other bad facts in this case too. I mean, the directors were actually granted very large equity awards in this situation, and I think there was questions about executive comp practices too. So this may be a situation where the old truism or law school truism applies of, well, maybe bad facts are making bad law here. But in any case, the Delaware Supreme Court didn't, you know, really scrutinize that limit and say, well, how meaningful is it? They just said, look, the directors have discretion, and even though the shareholders have approved this plan with this limit, the entire fairness standard is going to apply. And that's going to be the rule, is what they seem to suggest, except for just a couple of much more narrow situations where one is if the shareholders are approving specific awards to directors, so for example, you granted an award subject to shareholder approval, or where you have a non-discretionary formula plan that's approved by shareholders, where the plan just specifies what the grants are going to be to directors each year, and it just kicks out that number of shares. If you have that type of an arrangement and your stockholders have approved it, then you get a stockholder ratification defense and the protection of the business judgment rule. But other than that, the ruling just suggests that you may not get that protection under Delaware law anymore.
Right, and of course, you know, I don't think the marketplace is going to move to having formula plans or approving specific director awards, certainly. And so, you know, what we're doing is we're still including limits on director comp in the equity plans. And also, you know, directors just need to make sure that they have an independent comp consultant that'll come in and that they're reviewing their comp on an annual basis. Typically, the SEC likes to see either non-gov or the comp committee reviewing the comp and then making recommendations to the entire board. And then we're also, as Nathan mentioned earlier, trying to have more robust disclosures in the director compensation section, talk about how the compensation is set, you know, where it falls with the benchmarking and such. And I think with all those activities and protections, you're probably going to be okay. But yeah, it's unfortunate that the law is a little bit more unsettled than it had been in the past on this issue.
Mm-hmm. Yeah, hopefully it might develop in a more favorable way in the future, but it's definitely a point to stay tuned to the law in this area. But I agree with Shane, and I think it still makes sense to include the type of what we viewed as meaningful limits on director compensation in shareholder approved equity plans. Keep those in your plans for now, and we'll see where the law goes from here.
So we always try to provide an update on Dodd-Frank. That is the Dodd-Frank Act of 2010, and 8 years later, we're still sitting here talking about proposed rules that have not been implemented. But in any event, the first one relates to clawback policies. And the IRS did issue some proposed rules on clawback policies in 2015, but they have not been finalized. And, you know, given the current administration, we don't expect these things are going to be finalized anytime soon. But clawback policies are in the news a lot because a lot of companies have voluntarily adopted clawback policies, perhaps not as stringent as what would be required under these proposed rules. But it's seen as a good practice. And again, a clawback policy basically states that if you get paid a bonus, as an example, based on financials that are subsequently restated, then you agree to pay back the money that you shouldn't have received based on the faulty financials.
Mm-hmm. At least if you were culpable in some sense under existing policies. Yeah, the Dodd-Frank rule, if it ever enacted, would absolutely be a no-fault rule. But you know, in terms of current policies that are out there, often it may depend on, you know, what the executive's culpability may be, and the board may have discretion to determine from whom to claw back if there's a restatement event. That's
right. And then you also see clawbacks in the news a lot because of, as an example, the Wells Fargo issue where Wells Fargo was able to use clawbacks that it had adopted that had nothing to do with financial restatements, but had more of kind of like a, detrimental activity clause or a bad boy clause, saying that if you engage in bad acts, we can go get your compensation back. Forget if there's a financial restatement or not. And so companies are still kind of playing with what the right discretion is in their clawback policies and how broad they want them to apply. And then certainly if the SEC ever finalizes these rules, companies will have to go and make sure that they have a no-fault clawback policy that applies for restated financials. But again, I just don't see this happening anytime soon.
Mm-hmm. I guess I would say we do at least now have, I think just recently, a full slate of SEC commissioners. So that's something.
Right.
Had been a vacancy for a while. I think we now have 5 SEC commissioners, so some things could move, although these provisions are probably ones that are much less likely to move under the current administration than others might be. Another one of the Dodd-Frank executive comp corporate governance rules that's hanging out there is the pay for performance disclosure rules, which were proposed back in 2015. And if those rules were finalized, they would require that companies use total shareholder return on an absolute and relative to peer basis to as a way to illustrate the relationship between pay and performance. The rules would require they were very prescriptive the way they were drafted in proposed form. There was a table for the pay versus performance disclosure where you would have to show performance for the CEO, performance for the other named exec, or pay for the CEO, pay for the other named executive officers against company TSR, against peer group TSR, and compensation actually paid, which the proposed rules had to come up with a definition of what was actually paid. And then they'd also require sort of a narrative description of what the relationship was between pay and performance, specifically related to TSR. Certainly, we have seen recently that TSR becoming a more and more prominent metric in company incentive plans, and this, if it was enacted, I think would continue that approach. But again, who knows whether these rules ever see the light of day in terms of final rules. I think there's just one more Dodd-Frank Shane that's still hanging out there.
Yeah, where the SEC had issued, these are the hedging policy rules for the SEC issued proposed rules in 2015. If finalized, companies are going to have to disclose whether they permit employees or officers or directors to basically engage in hedging transactions with companies' securities. And, most companies have an anti-pledging, anti-hedging policy in place, and they disclose it in the CDNA. So this is pretty much a non-issue, but it's something that came out of Dodd-Frank, and we're still waiting for guidance on that. So we will begin a Q&A session in just a minute. And if you would like CLE or HRCI, please note the attachment on the right side of your screen where you type in your questions. You'll need to print and complete that attorney affirmation form to receive credit. You will need to include the code on the form, and the code is TH96. So that's T as in Tom, H as in Harry, and the number 96, TH96. After today's session, you will receive via email a very brief survey regarding the webinar. The survey will only take a few minutes to complete, and we would appreciate your feedback on the presentation and how we may serve you in the future. Now, we can move on to a Q&A session. Please type them in your question box, and we'll address them as they come up with the time that we have remaining.
All right, for the Q&A session, we have one question that's come in, which is one that relates to the CEO pay ratio disclosures. And the question is, if the median employee from 2017 leaves the company during 2018, then when you're doing your next CEO pay ratio disclosure, can you substitute a similar compensated employee, or do you need to run the test again? So can you just find someone who was like the median employee, had similar compensation, and use that person, or do you have to go back through the whole process for identifying your median employee? And the answer to that question is the SEC rules say yes in that scenario where your median employee has left. you can substitute someone who is similarly situated. So one of those rules that was fairly helpful in terms of the SEC's guidance on CEO pay ratio disclosures.
Well, so not sure there are going to be any other questions, but I guess we will close it out. Thank you all for attending our webinar today, and please take a few minutes to complete the evaluation. And remember, if you want CLE or HRCI credits, you must complete and remit the attached form to us as we discussed. And thank you so much, and have a wonderful afternoon.
Yes, thanks, everyone.